This is the second in a podcast series picking up on particular aspects of construction law and professional negligence, but particularly dealing with the ramifications of the Building Safety Act and the various claims that are being pursued in the light of that legislation. You may have already watched our previous podcast where we discussed both the context behind the Building Safety Act and also a key cause of action under the Building Safety Act, namely building liability orders. Today we're going to be moving on and discussing some of the other orders that might be provided for under the Act, including remediation contribution orders and remediation orders. And we'll be talking a little bit more about the sorts of claims that are likely to be brought against product manufacturers. But just briefly, it's worth mentioning that I'm joined here, of course, by Sian Mirchandani, KC, again, who has extensive experience in construction disputes and building safety disputes like those that we're going to be discussing today. And I'm Paul Fisher, and I've worked with Sian a great deal on these kinds of cases. We've dealt with building liability orders. But the question on many people's minds after the Building Safety Act was introduced was, well, how do I make a third party meet the costs of remediation, or indeed to undertake the remedial works themselves directly? And that's provided for under the 2022 Act in the form of so-called remediation contribution orders and remediation orders. Before we deal with both of those types of orders, it's worth reminding ourselves, as we did at the start of the last of our podcast series, that critical to this legislation is protecting leaseholders. And one of the big fears post-Grenfell was that building safety defects generally were going to be remediated and the costs of those works were going to be recharged back to the leaseholder by way of the service charge provisions in their leases. And what the Building Safety Act does is introduce Section 122 and Schedule 8, which essentially means that leaseholders' liability for service charge under relevant leases cannot be used to claw back the costs of remediating historical safety defects. But when those costs are in fact incurred, one might want to recover them by way of a remediation contribution order. One might actually be able to force an entity to undertake the remedial works in the first place under Section 123 under remediation orders within the Building Safety Act. The Building Safety Act allows for remediation orders to be made by the first tier tribunal, which we'll refer to here on in as the FTT. And that order requires a relevant landlord to remedy specified relevant defects in a specified relevant building by a specified time. And I emphasize those terms because, of course, they are terms of art, which we'll come on to consider. In relation to remediation contribution orders, Section 124 of the Act states that the first tier tribunal may require a specified body corporate or partnership to make payments to a specified person for the purpose of meeting costs incurred or to be incurred in remedying relevant defects relating to a relevant building. There are those terms again, relevant defects, relevant building, which we'll come on to in a moment. But just as with our last segment in this series, you'll remember that Sian reminded us all of the just and equitable phrase that's included within the Building Safety Act. And if one is to obtain an order from the first tier tribunal for a remediation contribution, then one must prove that it is just and equitable to make that order. And it's important to remember that when we're dealing with the question of relevant defect, that we're not just discussing non-compliance or instances of non-compliance with building regulations. The definition of relevant defect goes much wider than mere non-compliance with the building regulations, and that's been confirmed in the recent decision in Gray and Edgware in the first tier tribunal. We also have to bear in mind Section 121, which deals with associated persons and gives a great degree of breadth to the potential net that is cast by these provisions because the RCO regime can be expanded to associated persons via the similar control provisions that we found in respect of the building liability order regime that we discussed last time. So let's just briefly talk about what we mean by relevant building, qualifying lease, and time. A relevant building under Section 117 of the Act is a self-contained building or part thereof of 2 or more dwellings at least 11 metres high, or one might say at least 5 stories. That means that we're not just dealing with high-rise buildings of over 18 metres. We're dealing with also these medium-sized buildings of over 11 metres in height or 5 stories. So that's worth bearing in mind when we look at the scope of these provisions. As regards the qualifying lease and qualifying time provisions, that means a long lease of a single dwelling in a relevant building of more than 21 years. The tenant is liable to pay the service charge. The lease was granted before the qualifying time, namely the 14th of February 2022. And the tenant has a home or UK-owned property or owns no more than 2 additional properties in the UK, according to Section 119. Now, really important to remember that these provisions attach to the lease. The lease itself is the thing that qualifies, not the leaseholder. And so the lease status passes to new owners. We've touched briefly upon the question of relevant defect. We've made it clear that one isn't just looking at non-compliance with building regulations. Section 120 defines a relevant defect as a defect as regards the building, arising as a result of anything done or not done, or anything used or not used in connection with relevant works, that causes a building safety risk. Now, a building safety risk has been identified as anything above and I quote, low risk. Now, that is quite a low threshold, and it was declared in the FTT decision in Gray and Edgware. Now, in that case, it was submitted to the tribunal that, in fact, the test should be an intolerable risk, but that was rejected. Anything above a low risk may constitute a building safety risk. As regards the definition of relevant works, those are works relating to the construction or conversion of the building, works undertaken if the works were completed in the relevant period or afterwards in order to remedy a relevant defect. And for that, we look at Section 120, subsection 3. The relevant period tracks that 30-year extension to the limitation periods that we discussed in the last segment of this series, meaning that the relevant period is 30 years ending with when the section came into force on the 28th of June 2022. But earlier we touched upon Section 121, which deals with the question of associated persons. And this could become very significant indeed as we see the scope of remediation contribution orders expand in order to find the money by reference to various third-party entities who had a connection with the works and or the building. Now, associated persons is defined under Section 121 as a partnership or body corporate which is associated with another person in the circumstances mentioned in subsections 2 to 5. Now, subsections 2 to 5 will require very careful analysis based on the facts of any given case, but might broadly be summarised as follows. You may well have a beneficiary of a trust of an interest, which constitutes an associated person. Associated partners and partnerships will fall within that definition. Body corporates associated with directors may also fall within the definition. And also, we have to bear in mind subsection 5, which defines a body corporate as being associated with another body corporate if at any time in the relevant period a person was a director of both of them, or at the qualifying time, one of them controls the other, or a third body corporate controlled both of them. The headline here, of course, is these are quite complicated provisions which will require very careful consideration in any given test. But the control tests that we're concerned with here are the same as in respect of building liability orders. But the takeaway point is that Section 121 is very broad, and that was confirmed in the Gray and Edgewater case that I mentioned earlier. And it's important to bear in mind that one might see the tribunals and courts using the test of just and equitable in order to curtail perhaps some of the broader and expansive effects of Section 121 in future. So now I'm going to turn to Sian, who's going to discuss with us some of the claims against manufacturers that are ongoing or indeed exhibit on the horizon.
Thank you, Paul. Yes, the claims against manufacturers is a new area, a new cause of action that's part of the Building Safety Act 2022, and it is the operation of sections 147 to 149. What these sections are aimed at is a new cause based entirely out of the statute against construction product manufacturers. And it isn't just the makers, it's any economic operators, any person who markets or supplies a construction product. And you'll note that the wording is, again, quite broad. It's not just cladding, it's any construction product. What, in summary, where the cause of action is looking at is situations where a product has either been missold, is inherently defective, or means that there are breaches of the existing regulations. Now, those existing regulations, for example, in the construction product regulations 1991, or the regulation EU number 305 from 2011, and the construction products amendment EU exit regulations of 2019 are where you would have to be looking to see if there are breaches of the existing regulations. And the kind of thing that you're looking at is, for example, under Article 4 of the 1991 construction product regulations, you're considering the declarations of performance that have been made by the manufacturer or the marketer of the product. And you would be looking to see if the product, as now known, given we've had the inquiry after Grenfell Tower fire, and how we know that some aspects of the testing of these products were deeply suspect, as to whether they were in fact a product in conformity with the declaration of performance that was given under those regulations. Another aspect one might look at is, for example, the CE kite marking and whether that had been correctly obtained. These are the claims that involve looking for economic loss, where a person is liable to pay damages to a person with a relevant interest in relation to a relevant building for personal injury, damaged property, or economic loss suffered by that person as a result of the facts referred to in the following parts of the Act. And once again, this section of the Act, like the building liability order sections, requires conditions to be met for the remedy to be available. The conditions are A to D at sections 148, subsection 2 to subsection 5 of the Act. And in turn, they are the requirements that you would be looking for to establish whether you have a basis for pursuing this as a cause of action. So firstly, condition A is that at any time after the coming into force of the section, a person fails to comply with a construction product requirement in relation to a construction product. Then subsection B of it is that a person who markets or supplies a construction product makes a misleading statement in relation to it, or C, a person manufactures a construction product that is inherently defective. So you have three ways of achieving condition A. Then condition B is that after condition A has been met, the construction product that is referred to in one of those subsections A, B, or C has been installed in or applied or attached to a relevant building in the course of works carried out in the construction of or otherwise in relation to the building. So clearly, once you've got a situation where a product is, you can show that you've met condition A, you then have to show that it is in fact installed in the building, condition B, fairly obvious condition that would have to be met. Then condition C is that when those works are completed, In a case where the relevant building consists of a dwelling, that the building is unfit for habitation, or in the case where the relevant building contains one or more dwellings, a dwelling contained in the building is unfit for habitation. And of course, that unfit for habitation is the same formula that we know very well from the Defective Premises Act. Condition D is then that the facts that have been referred to in the subsections A, B, or C, which related to the being missold, being inherently defective, or breaching the existing regulations, that those facts were the cause or one of the causes of the building or dwelling being unfit for habitation. So it's a causal link between the conditions that we've just gone through. So who are the people and the entities that can bring such claims against manufacturers? Well, the first thing is that the claimant would have to have a relevant interest, and that would be a legal or equitable interest in the building or the dwelling within the building. So potentially that would be the building owner. It could be a leaseholder, the freeholder. It could be a property company or a management company if they have an equitable interest. One could also have situations where insurers may be able to take an assignment of an interest for the purposes of pursuing such a remedy. That there will have to have been suffered a loss due to the dwelling being unfit for habitation. And such consequential losses might be to, for example, to be unable to occupy, obligations to repair and reinstate, fire safety requirements such as the waking watch costs that we have heard about so often since the Grenfell Tower fire. They will have to be pursued in the name of the claimant. And as I've mentioned, insurers might want to step in, but they would be pursuing the claim in those circumstances in the name of the claimant, or there would have to be a manner of assignment so that they can take the course of action and pursue it. The route for the contribution claim would be via the usual same damage test and looking at the unfit for habitation aspect. It's available also for cladding products and past defaults, because Section 149 provides for a similar regime. And in terms of limitation, one of the beneficiaries of the extended limitations, so for completed works, i.e. retrospective claims, the limitation period is 30 years. And for works that have been completed after the 28th of June, so prospective claims, the limitation period is 15 years. So plenty of scope for future claims in this area. There will be quite a lot more discussion about these matters in future podcasts that we've hope to be dealing with before too long. But the way things are with these manufacturers' claims at the moment is that there are only a few that would appear to have actually not ended up in the settlement, so far as I can see. But perhaps by the time we do the follow-up podcast, we will have some more information about the actual cases involving those pursuits of claims against manufacturers. It's certainly an area that everybody who has paid out in relation to these sorts of claims has been thinking about from day one.